Hi, this is Mary Guzman, founder and CEO of Crown Jewel Insurance, and you are here for the third episode of Season 2 of our podcast, Cover Your Assets with Trade Secret Insurance. And today I am absolutely thrilled to be joined by Roy Locke, who is a Senior Vice President in the M&A Transaction Risk Group for Marsh. He is a knowledgeable expert around all things related to transaction liability insurance, and he's going to answer some questions that I have around how the market perceives trade secret risk, etc. Welcome, Roy.
Thank you. Pleasure to be here with you on this beautiful afternoon.
Time flies.
Yes, it does.
Roy and I have something in common. Both of our children just graduated from the same high school this past weekend, so that was exciting.
Yes, it
Congratulations.
was. Thank you. Same to you.
Thank you. So with that, I want to give it a little bit of background on why I thought this would be an interesting topic, and then we'll jump into a few questions that I had. So in the rep and warranty space, during a transaction, obviously there's a fair amount of due diligence done around, well, there's a lot of due diligence done for the target company around all types of things that end up being reps and warranties in the deal documents. This is for people who don't do reps and warranty insurance every day, that are then insured in a rep and warranty policy, which is designed to cover things that were not known at the time that the deal was done, but are discovered post-close that, if known, would have caused the deal price to be different, or maybe the deal wouldn't have gotten done, and the insurance proceeds are there to make up the difference for that. So obviously, companies look at the companies that they, or the portfolio opportunities that they potentially want to acquire, and do a lot of due diligence around various factors of their business plan and their launch strategy and all of that. In today's environment, a lot of the value in companies that are being acquired is in their innovation assets, including trade secrets. My understanding from talking to one of our valuation firm partners who happens to handle some claims in this space on behalf of some of the carriers that are in the rep and warranty market is that there have been a couple of claims that have come to the fore where the timing of a claim was perfect. In other words, it met the definition or the trigger that would normally be expected under a rep and warranty policy, where in the due diligence documents and the deal documents, the seller represented that they did not know that their intellectual property assets have been compromised in any way, shape, or form. They represented that they owned them, of course, that they developed them and they had the rights to those IP assets, and that they were using quote-unquote industry best practices to protect that information. And I would expect that that is very standard language in a lot of documents that the buying entity is going to see during one of these transactions, and all sounds great. The problem is that if there is nonetheless a misappropriation of those intellectual property assets, specifically trade secrets, that has occurred but doesn't become known until after the deal closed, now all of a sudden you've got a buyer who invested in a company or paid completely for a company that was, $11 million. I don't know why I picked 11 instead of 10, but $11 million.
You're accounting for the retention.
Yes,
the policy,
exactly.
So.
There you go. I don't think in round numbers for some weird reason, but so they bought a company that they thought was worth $11 million, largely based on their IP asset, but that asset has now been posted on the dark web, for example, for all to see. And now they've got 4 competitors who can come in and do almost exactly the same thing. So obviously their market share is going to be diluted. The other 3 or 4 parties that have access to that information that were maybe getting close but not hitting the nail on the head now are going to avoid all of those R&D expenses, so they're unjustly enriched by this whole thing. Therefore, now the buyer makes a claim under the rep and warranty policy. In this particular scenario, my understanding is that the rep and warranty policy did not respond simply because there wasn't a rep that was breached in the first place.
Correct. And that is the biggest part of getting coverage under a reps and warranty insurance policy. At the end of the day, it is, how is your representation drafted? such that there is a claim for a loss under a reps and warranty insurance policy. So a lot of times sellers will make a rep that, to our knowledge, we're not aware that that our IP is being infringed by any third party. And if that's the case, and if that's the rep that's given, it is pretty hard to recover under that, because first buyer would have to prove that seller did have knowledge of that in order to be able to recover for a breach of that rep. What we are seeing in the market is that, if a rep is given where it's not knowledge qualified, that is great for buyer. Most likely, the insurance company is going to deem that rep to be knowledge qualified inside of their policy, so that even if the rep is not knowledge qualified in the acquisition agreement, it will be deemed knowledge qualified in the policy. So that is a scenario in which you would have some kind of limited recovery under a reps and warranty insurance policy for an infringement claim. That being said, we've covered a number of infringement claims. We've received a number of infringement claims, not covered, but received a number of infringement claims where our insurance partners have actually covered such claims, depending on the facts and circumstances.
Okay. And in those infringement claims, though, I'm guessing, and I could be wrong here, that for the most part, those are going to be liability claims. Correct?
Third party that someone else is infringing upon the target's intellectual property.
Gotcha. Okay. So what I'm really trying to pinpoint here, and that's really important to know because there at least is some recovery for intellectual property related claims if the timing is right and all of those things, and certainly the seller did not know.
Right.
But what we're trying to cover is the actual value of those assets that before the transaction are owned by the seller, post the transaction they're owned by the buyer, and now the value of that asset has sunk through the floor because it's either no longer a trade secret, which means that you can't litigate around it and protect it. Once it becomes public knowledge, a trade secret loses its value and it goes to zero. Or that simply there's just now all this additional competition that's eating into market share, and so you've lost the value of that asset.
Yeah, so, in every acquisition agreement, you are going to have a rep that's given by the sellers that says there's no undisclosed liability other than what is reflected on the balance sheet in the company. So traditionally, if a particular rep did not address a scenario head on, your undisclosed liability rep is usually a source of recovery for a buyer. However, it's not a be-all, it's not a silver bullet. You do have to go and establish that, this wasn't an undisclosed liability, that, seller was not aware of it, didn't come up in diligence, buyers didn't have any prior knowledge of it. But there may be some circumstances where if you have an undisclosed liability rep inside of an acquisition agreement and you have a definition of loss that would include diminution in value, so the value of what you've purchased has now been diminished, and you have an insurer that is actually willing to cover that, and we have seen instances in which insurers would be willing to cover that subject to additional premium being paid, then maybe you have a scenario in which that can be covered. But again, all of those factors have to line up in order to get the coverage under that reps and warranty insurance policy.
Okay. That is really useful information. So then I guess that begs the question, when you are counseling buy-side companies, or just when you're involved in a deal in general, what is your perception about how much time and energy is spent in the due diligence on not only the ownership of the IP, but the protection around it? And the reason I'm asking that is that under trade secret law specifically, and I I don't mean to be woman-splaining to you.
Your IP splaining, which is fine.
Well, there you go. Because you're an attorney, and you might know this already, but for our audience members who don't.
I am a former corporate attorney, corporate M&A attorney. We touch IP in our transactions. We touch every single area. So, you know a little bit about IP, you know a little bit about employee benefits and so forth, but not enough to say, you're an expert in this area. So
Okay.
I welcome the explanation about trade
then I will
secrets.
woman-splain away. I love that. Love to be able to woman-splain. So essentially in trade secret law, the wording is very nebulous and vague on purpose, which is frustrating to those of us who are trying to enforce it. Lawyers love it if they get to litigate around this vagueness because it says that clients just have to use reasonable measures, quote unquote, to protect their information. So if the diligence documents or the deal documents also say we are using reasonable measures to, or industry standards, which I would imagine is very common in a lot of these documents. Because as a cyber broker for 20 plus years, I used to read contracts every single day from our clients that were saying from a cyber perspective, we use reasonable or industry standard security. Usually that was more about PII or PHI, but in this circumstance, I would imagine it's very similar language. So that begs the question, what is reasonable security? And so if we don't know what reasonable security is, then you would want to default to sort of more robust security than not if you're buying a company based on innovation assets. And at the very least, you want to be able to get a restraining order, some sort of injunctive relief, or try to get your asset back. None of which you can do if you can't show that the asset was being protected using reasonable measures. And so I'm just curious if there's a lot of time and energy. My suspicion is there isn't a whole lot of time and energy spent on what reasonable measures are around the protection of trade secret assets, but
Yeah.
I ask you that question.
It's interesting. I'm trying to think of any particular deal that we've worked on where, trade secrets was the, focus of the assets being acquired. I mean,
That in and of itself, I'm sorry to interrupt, but I find that really interesting. I can go off on a tangent, but I won't, about how I think that's a huge mistake just in general in businesses in the United States because they're so focused on patents and how many patents you have and how many patents you've applied for that people forget about trade secrets, and they absolutely can be more valuable than patents for a lot of companies.
Well, a lot of the deals that we're doing now is in the, what we categorize as communications media software space.
Okay.
And we've done, for whatever reason, we decided to lump them all together.
Mm-hmm.
But we've done a number of software deals where, what's important is, hey, who owns the IP here? Who owns the intellectual property, the know-how and so forth? Whether or not it's been, quote unquote, labeled as trade secrets, I haven't seen that, flying back and forth inside of the materials.
Gotcha. Okay.
But that being said, any buyer who's looking to acquire a software company, they want to know that the target has all of the rights to that particular IP so that if they want to use it somewhere else or in some other capacity, there's no restrictions on that use. They want to know that there's no, copyleft, software that's inside of that software where they'd have to disclose, their source code, things of that nature.
Mm-hmm.
So open source is a big issue when you're acquiring a software company.
Okay.
And that's a lot of the diligence that we do see where people are looking to see whether or not something is open source, not open source.
Okay.
We will see penetration testing, just to make sure that their IT systems are secure.
That's good.
They are sweeping to check to make sure there haven't been any breaches, there haven't been anything. But
does that exist outside? I'm sorry to interrupt. Does that exist outside of software company acquisition? Because
probably to a lesser degree.
Okay.
If I am working on a manufacturing deal where they're acquiring a series of butcher shops or butcher industries, IP is probably not at the forefront of that target business.
Yeah, gotcha. Well, that's the interesting thing is that I think a lot of times people overlook that the reason that a manufacturing company or a logistics and supply chain company or green energy company is doing so well or is going to
is because of their IT systems,
because of their business processes,
yep.
which are by definition trade secrets.
Yep.
And so once again, I think it's kind of an overlooked asset, but that is really interesting. So switching gears for just a second to the portfolio company risk, and I know this is a little bit outside of your niche because you have another group called PIMA, I think internally at Marsh, that handles the placement and recommendations around the insurance for the portfolio companies outside of a transaction.
Yes, correct.
But certainly trade secret misappropriation risk exists outside of a transaction, and in fact, we would rather see people dealing with it outside of a transaction because it takes a little bit of time to get your hands around it and really underwrite it and understand if the proper protections are in place, and that goes well beyond just software code. It could be financial algorithms, recipes, drawings, designs, business processes, et cetera, et cetera. But my sense is, I know, having spent some time at a couple of conferences, that a lot of times cyber insurance is required now, which I'm happy to see and hear because I spent so much time pounding the pavement and screaming from the rooftops that was an exposure when nobody cared.
Yeah.
But I'm glad to see that it's much more mainstream now. But I think there's a perception, perhaps a misconception, that cyber policies will cover the value of trade secret assets or other intellectual property assets if they're stolen during a hack. And therefore, if you're requiring that the seller have a cyber policy in place, that's all well and good. The reality of the way that cyber policies work is that they are very well designed to cover all of the costs and expenses associated with the theft of personally identifiable information. And even though the insuring agreements say that corporate confidential information is also covered, it's a covered asset. If you read the insuring agreement of virtually any cyber policy, you're golden if you just read the insuring agreements. The problem is the valuation clause states very clearly, and or you might even have an exclusion, that a cyber policy is not intended and will never cover the value of the asset itself. It will cover the cost to replace the data, for example. So if the asset in question is a pharmaceutical drug formulary, or the Coca-Cola recipe, or a new orange soda recipe that Coca-Cola is coming out with, and they've gone through 37 taste tests, and they're in test markets all over the U.S., and they keep changing the taste and maybe even the color a little bit to make it more pleasing. All of those wrong turns and all of that stuff that they did to get it to that point is not going to be covered by a cyber policy. Almost certainly. You may be able to make some arguments if the policy wording is exceptionally broad, but the other part of the value of a trade secret is on the future value of that asset over the lifetime of that asset, brought back to net present value. So if you're not going to change that orange soda formula, probably based on your historical experience, for 7 years after you release it, and you're going to capture 11% market share, well, if you all of a sudden
no longer have that
protection, obviously that's going to diminish the value. Getting back to the cyber thing, I think a lot of brokers think, and therefore advising their clients, that those types of values are covered under a cyber policy, and they're not, number one. And number two, I think that some of the rep and warranty markets have no broader than wording in their policies now that say, if there's a cyber policy in place, that's awesome, and we'll cover the same exact cyber losses under our policy to the extent that they raise their ugly head in a rep and warranty situation. But if they're no broader than the underlying cyber policy, which doesn't cover the value of IP assets
then
anyway,
the reps and warranty insurance policy won't pick up that loss either.
Correct.
Yes. One of the things that we are seeing in the market, just given right now that we are in a soft M&A market, is that one thing we are seeing is that, in order to be competitive, a lot of insurers are removing that no broader than language.
Oh, wow.
And so there is arguably a place for coverage, and I'm not saying it definitely will be. It's all facts and circumstances dependent.
Sure.
But in that scenario where a reps and warranty insurance policy is either silent as to whether or not it's sitting specifically excess of underlying cyber, or may specify that we're sitting specifically excess of, but they won't limit it to no broader than, you may be able to get coverage under a reps and warranty insurance policy that you would not be able to get under a cyber policy if the loss still arises from a breach of a rep, or more accurately from the breach of a representation.
Oh, got you.
So it can't just be a hacking event. There has to be a representation that says, we haven't had any hacking events in our IT systems, are free and clear from all viruses, Trojan horses, worms, et cetera, et cetera. That's usually part of the standard IP rep.
Right. Okay. And it gets back to the knowledge issue, which is a little scary.
It gets back to knowledge and timing. So one of the things that happens is, a buyer will acquire company A. They close on June 30th. August 1st, they discover, hey, we've had a worm inside of our system, and now all of this information is gone. The question becomes, well, when did that worm, was that existing at the time that you purchased it, or did that happen afterwards? If it existed prior to the time that you purchased it, there may actually be recovery under a reps and warranty insurance policy after you've gone through the deductible to recover under the reps and warranty insurance policy for that, depending on the nature of the rep.
Interesting. Okay. Yeah. Again, once again, based on the actual circumstances and how the wording is drafted. That's
why the lawyers get paid what they get paid.
Yes, exactly. Well, but I do want to just hit home again the fact that
issue.
Well, and the fact that yes, the trade secrets issue, but outside of the transaction, a lot of these portfolio companies are, the brokers that are in that space have a due diligence checklist. Do they have cyber? Do they have workers' comp? Do they have crime, D&O, fiduciary, EPL? Do they have X amount of limits? And they're doing what they can based on what's available in the marketplace. But if the cyber policy isn't ever going to cover the value of trade secrets, then outside of a transaction, there's never coverage for this either.
Right.
So it's just something that we really want to make organizations aware of.
I definitely think there is a space for this product out there. Just the little that I've learned over the past couple years as this has been introduced, I definitely think there's more room to grow for this trade secret insurance. So I'm very excited to have this be a part of this and just be able to tell my clients, hey, here's something out there that exists. So.
Well, that's awesome. We would appreciate you doing that. The other thing that I want to just before we close, something else that it makes this really timely that I wanted to make sure that our audience is aware of. And I'm hoping, Roy, that you're going to go share this with your millions of fans around the world on social media, etc. Essentially, one thing that is really driving this discussion right now and is making it really important that we as advisors in this space are talking to clients about this is that the FTC, as you know, has proposed a ban, an all-out ban for non-competes. Which already exists in California and a couple of other states. Interestingly enough, according to, I believe it's Stout, but it could be Ocean Tomo. Please don't yell at me, either one of those companies, if I'm misquoting, if I gave one credit and not the other. But essentially, in California, where non-competes are not enforceable and have never been, the success rate on litigation, the plaintiff winning in trade secret litigation, is almost 20% less than most other states. So it does have a direct impact on the wins and losses around trade secret litigation, whether or not non-competes are enforced. But again, I think that's not because non-competes are the be-all, end-all as much as it is because companies aren't doing the other things they need to do, which is identify, value the assets, and put specific mitigation procedures around them. But if non-competes are banned, then that means, especially in the M&A space, where a buyer is looking at a seller largely for their innovation assets, whatever those are. It could be any number of things. If non-competes go away, then employees are going to feel emboldened, incorrectly so, but they are going to feel emboldened to take not only people with them and clients with them, but innovation assets that they worked on while they were at their prior company because, damn it, I worked on this, financial algorithm for 6 years and it was my baby and I own it and I have the rights to this and I'm going to take it with me.
So notwithstanding the doom and gloom perspective there, I do think that the legal industry, so a couple things. One is, as we sit here now, I think there's going to be a lot of legal challenges to the FTC on those non-competes.
Agreed. Absolutely.
And I don't know how successful they will be, especially that you're looking to institute this nationwide.
Yeah.
So
agreed.
I really
They're going to get sued.
Yes.
It's going to be a long, drawn-out process.
I don't even think that's going to be successful. But even for argument's sake, let's say they are successful in passing this rule and banning these non-competes. I think the legal industry will come up with enough workarounds that you will still have the protection in place through other forms of agreement. So there are, assignments of IP that people have to sign when they first start a company, saying that, whatever IP I create while I'm here employed by you belongs to the company and not to me as an individual. I don't think those are going to go away, even if non-competes go away. So I think
that's good.
I think there are a number of different, tools and contracts and so forth that, my kind, the lawyers, will come up with where we will still have certain protections in place. That being said, for
I wholeheartedly agree. By the way,
for companies that have already gone down that route and there are non-competes that are in place and so forth, yes, it is something that is worth considering. So.
Yeah, I just think we need to be raising this as a flag. Maybe not a red flag, but certainly a flag
Something
for a
to
lot
be
of organizations because there are some companies out there who have used non-competes as kind of one of the only measures, frankly, to protect themselves from theft of trade secrets and IP. To me, that's, can I say this, sort of the lazy way of approaching this risk where they're not, doing all the other things, identifying specifically what the trade secret asset is in the first place, giving notice to the people who have access to that know-how that we consider this to be a trade secret, like you were just saying, and you cannot take this with you when you go, and that those employees who have access to it can still be subject of a non-disclosure agreement or some other contract like you were mentioning. I'm not at all convinced that a lot of companies are doing that right now.
I think a lot of the bigger companies are and the larger companies are. So, if you're of a certain scale and a certain size, you are probably onboarding when you first start and you acknowledge that you've read the employee handbook, and the employee handbook has the assignment of IP in it, and it's got the non-disclosure agreements in it, and it's got the non-competes currently in it. It's all in there, but for your smaller companies that are not of scale and so forth, I do think it is a risk there.
Yeah. Okay.
So,
well, thank you so much, Roy. It has been a lovely conversation. I really appreciate it. How can people find you if they want to get in touch with you?
Sure. I am at Marsh, as you mentioned, and I am on LinkedIn, Roy Locke, L-O-C-K-E. On LinkedIn, also can be reached at roy.locke@marsh.com.
Awesome. Thank you so much.
Thank you.
And for those of you wanting to find out more about what we do, which is, of course, risk mitigation and insurance around trade secret assets, you can find us at www.crownjeweliinsurance.com, www.tradesecretinsurance.com, or follow us on LinkedIn. Thank you so much. I appreciate it.